All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Judge Motok.
Bonjour,
Good afternoon. I'd like to welcome everyone here inside the courtroom and those outside the courtroom. Court officer, kindly call the case.
Good afternoon, Your Honors. This is the situation in Libya in the case of the prosecutor versus Khaled Mohamed Ali El Hishri. Case reference ICC 0111, 0125, and for the record, we are in open session.
I would now like to ask parties and participants to introduce themselves. I'd like to begin with the Office of the Prosecutor. Kindly proceed, ma'am.
Good afternoon, Your Honors. For the prosecution today is Ms. Jessica Lacey, case manager, Mr. Renz Vanderwerf, trial lawyer, Mr. Hisham Murad, trial lawyer, and myself, Nicole Sampson, senior trial lawyer.
Merci.
Thank you very much. The chamber thanks you. And now I would like to call upon defense counsel to introduce himself and his team.
Thank you, Madam President. Thank you, dear judges. Good afternoon, everyone. I am Yasser Hassan, senior counsel, and with me I have all my team members, and I have already sent their names to the employees of the court.
De M. Hishri dans la chambre d'audience. Je me tourne maintenant vers les représentants.
I note the presence of Mr. El-Shiri in the courtroom. I now turn to the victims. Ms. Masida, good afternoon, Your Honor. Here today we have Tars van Litzenberg, legal officer, Hamad Issa, lawyer and linguist, Anna Peña, case manager, and myself, Paulina Masida, senior counsel.
Merci beaucoup.
Thank you very much, counsel. And finally, representatives of the registry, please introduce yourselves. Thank you, Madam President. My colleague is we are here representing the registry, the unit responsible for cooperation within the registry, and myself.
Merci beaucoup. L'audience d'aujourd'hui est la deuxième conférence de mise en état de cette affaire. La première a eu le vendredi.
Now, the first status conference was on the 28th of January. Today's hearing is the second. The main purpose of these status conferences is to ensure that information is exchanged in a smooth manner and under good conditions with a view to the upcoming confirmation of charges hearing. I remind you that the beginning of that hearing has been scheduled for the 19th of May, 2026. Before beginning, I would like to remind everyone that our colleagues in the interpretation booths need us to speak slowly, and they need us to pause for at least 5 seconds before speaking. The agenda for today's hearing has been sent to you by email. The first point on the agenda is an update on disclosure by the Office of the Prosecutor. Madam Prosecutor, please proceed.
Your Honors, the disclosure by the prosecution is proceeding in accordance with the Chamber's instruction. We have to date disclosed 2,142 items of evidence to the defense team, which includes information that we intend to rely upon at the confirmation hearing, as well as information that falls under Rule 77 and Article 67(2). On 5 February, we completed disclosure of all of the evidence relied upon by the Chamber in accordance with its orders relied upon in the arrest warrant, and that included relevant translations of witness statements into Arabic. On 27 February, we completed disclosure of additional items not relied upon by the Chamber in the warrant, but relied upon by the prosecution in the arrest warrant application. And this also included Arabic translations. Within that pool of material, there were several summarized witness statements, which we disclosed in accordance with Article 61(5), and for which an application for authorization to disclose summaries will be made either this Friday or Monday, 9 March. We are completing now the remaining disclosures that we have to complete before 19 March, and we've anticipated already that that will include the witness statements of 14 witnesses in both English and in Arabic, which we will disclose on a rolling basis between this week and 19 March. Complementing that disclosure will be applications for non-disclosure of the identity of a number of those witnesses, which we also intend to file with the Chamber on a rolling basis starting next week. As we reported to the Chamber in our recent joint submission, 2 of those 14 witnesses' statements are being completed currently, and it may be, and we will assess this next week, that the prosecution will make an application for a narrow and limited number of days to disclose the Arabic translation of those 2 witness statements. However, we will disclose the English statements, which is a language that counsel understands and speaks, and will allow the defense team to prepare for the confirmation hearing and discuss the content of those 2 statements with their client in advance of disclosure of the Arabic translation. So we will submit, should such an application be made, that there should not be any impact to preparation or to the date of the confirmation hearing. Subject to any questions you may have in relation to our disclosure, those are the submissions I wish to make on that agenda point.
Judge Motok, thank you very much, Madam Prosecutor. I'll now give the floor to you, counsel, to speak to our first point on the agenda.
Thank you, Madam President. I will abide by the schedule that you have sent earlier. Yes, the Office of the Prosecutor have submitted 47 statements on a rolling basis starting the 11th of December 2025 and ending on the 27th of February 2026. However, only 41 of these statements had been translated into Arabic. 6 haven't been translated until now. The total number of statements or witnesses that include evidence is 53 statements. Despite that these statements have been with the Office of the Prosecutor for years, the first statement dates the beginning of 2018, and the last one is dated 7/7/2025. It would have been better that after all this period of time, these statements should have been translated and prepared for disclosure and handover. So, it's true that the defense team works in English. However, we are subject to the instructions of Mr. Al-Hishri when it comes to the submissions of the defense. And this is the main right of the accused. He has the right to access all the evidence in the language that he understands. However, there is also a remark about some statements that were handed over to us, and they were totally redacted or heavily redacted. Even the names of the witnesses and the data that reveal their identity have been redacted. So this redaction has been requested or submitted to the court, and the court has made a decision about it. However, I have two remarks here. The first is, how can we know whether this witness is a civilian or from the military at a time when all the personal data of this person are redacted? How can we verify whether this witness is affiliated to a military faction or not at a time when all the data is redacted? All the data that is redacted within the submissions or the disclosures of the OTP. This is one of the questions and not all the questions. Even Mr. Al-Hishri wonders, how can I face a witness that I do not know? How can I appeal, or how can I question a statement of a person that I do not know? However, here, Madam President, I will refer to the arrest warrant issued on the 10th of July 2025, where the judges decided, especially in paragraphs 15, 16, and 17 of the arrest warrant, to arrest Mr. Al-Hishri. And I will read some of these paragraphs. So, in paragraph 15, the court says, the chamber says, it must therefore be shown that a non-international armed conflict existed at the time the persons were arrested or otherwise detained. Here is the question. How can we know whether these persons were from the military or were civilian based on this paragraph? Because this stipulates whether these persons were protected by IHL or not. Second, in paragraph 16, so the same meaning here, the same assertion, and also this applies to paragraph 17. Therefore, Madam President, dear judges, in order to deal with the legal stipulations in these paragraphs, and based on what the chamber relied on to issue the arrest warrant, and within this heavy redaction that we have received on the redaction even of the names of the witnesses, so this impedes the work of the defense. And we know that the threshold of evidence, of proof at this point in the proceedings is rather low. However, now, Madam President, we are dealing with evidence. And the evidence that we cannot examine cannot be used for exoneration. And if the Office of the Prosecution submits that this redaction will be removed later on in the procedures, then at this point we will have deprived Mr. Al-Hishri one of the phases of the proceedings, because this pre-trial period related to the confirmation of charges, here the defense relies on these basic data and information. In the absence of such data and information, essential information, it would be impossible to examine or to contest these information, and this prevents the defense from defending our client effectively. Therefore, we would like to request you to review the decision of the 26th of February 2026, and I would like to ask you to review or look again into this as soon as possible. Thank you.
Merci beaucoup.
Judge Motok, thank you very much, counsel. I'll now turn to the representative of the OTP. Madam Prosecutor, did you wish to say anything in response in relation to this matter?
Yes, thank you, Your Honor. Counsel raised several issues in relation to timing of disclosure and redactions. So on the timing of disclosure, the prosecution has abided by the Chamber's orders on deadlines, and whether or not translations ought to have been made earlier is dependent on a very number of factors, but we have abided by those deadlines as given by the Chamber. Redactions to the identity of witnesses, of which there are several in this case, is permissible at this stage of the proceedings. The redactions have been reviewed by the Chamber and approved by the Chamber. They're necessary in order to protect victims and witnesses, and the Chamber has determined that they are proportionate and do not unduly affect the rights of the defense at this stage. Redactions of this nature also affect the Office of the Prosecutor in that we are unable to rely on information that is redacted in the course of the confirmation hearing. The defense had an opportunity to make observations, to object to and challenge these redactions, and they have done so. But the Chamber has approved them on the basis of its own independent assessment. The defense sought leave to appeal that decision, and it was rejected. Accordingly, in our submission, we must move on from the issue of redactions, or the defense can raise it at the appropriate time, which would be during the confirmation hearing itself. There are a number of witnesses whose identity has not been redacted to the defense. There are at least 23 witnesses for whom the defense has full access to their data. And even for the witnesses for whom their identity has been redacted, the substance of their account is not redacted. And therefore, the defense has information at its disposal upon which it can determine the basis upon a person's arrest and the harms that came to them during the course of their detention, which would be applicable both to the charges that are war crimes and the charges that are crimes against humanity, because of course we have charged both. Those are my submissions. Thank you.
Merci.
Judge Motok, thank you very much, Madam Prosecutor. Would any other party or participant wish to make further submissions on this point or observations? Thank you, Madam President. I'm sorry I interrupted you, says Ms. Masida. Thank you. We have no point to raise on this particular matter at this time. Thank you.
Merci beaucoup.
The presiding judge, thank you very much. Did the defense wish to speak once again to this point?
Thank you very much, Madam President. I would like to inform the Chamber that we are going to submit a document including all our objections, and we are going to ask the Chamber to reconsider the previous decision. Thank you very much.
Merci beaucoup.
The presiding judge, thank you very much, counsel. The Chamber takes note of the submissions from the parties regarding the process of disclosure and how it has been going so far. Indeed, the Chamber is encouraged by the process and how it is unfolding, and we state once again that it is important to meet the deadline of 19 March 2026. That is the deadline for all disclosure, in particular the translations into Arabic, to which the defense is entitled. Concerning the two translations of statements that are being finalized, the Chamber calls upon the prosecutor to make every possible effort to respect this deadline. If that is not possible for those particular translations or any other document in the possession of the prosecutor that could not be disclosed within the deadline, in possession of the prosecutor that could not be disclosed within the time allotted, the prosecutor shall file an application for an extension of the deadline before the 19th of March 2026, which is the date on which the deadline expires.
Prenons acte du calendrier.
Furthermore, taking note of the current schedule, and in order to not disturb this schedule, the Chamber orders the Office of the Prosecutor to file as quickly as possible these additional requests that have to do with the non-disclosure of the identity or witness statements, preferably on a rolling basis before the 19th of March. After receiving relevant responses and observations, the Chamber shall rule on these final matters as quickly as possible. The Chamber takes note of the observations made by the defense relating to the consequences of any delay in the disclosure process and shall examine these issues if there is a delay. The delays and the deadlines and the procedures relating to challenges of the jurisdiction and admissibility by the defense. This is the second point on our agenda, and I believe, Counsel, it is time for me to ask you to proceed. Please go ahead.
شكرا سيدة الرئيس.
Thank you, Madam President. Regarding the deadlines, we have submitted to you before in our joint filing that we are going to file our submissions regarding the jurisdiction and admissibility 2 weeks before the confirmation of charges hearing. We are right now waiting for some responses from certain parties that we have requested information from and that we requested cooperation and assistance from. And we don't have any intention to delay these submissions, and we don't have any intention to ask for any assistance from outside the court. However, we have already contacted some departments inside the court itself to request certain data, and we abide by the date 2 weeks before the confirmation of charges hearing. You will have all of our submissions. Thank you very much, Madam President.
Merci beaucoup, Maître. Maintenant, nous allons entendre les observations.
Thank you very much, Counsel. We will now hear the prosecutor on this issue. Madam Prosecutor, please proceed.
Your Honor, we took note of the defense's proposal to file the challenge to both jurisdiction and admissibility 2 weeks before the confirmation hearing date, and we did not put our observations in the joint filing, preferring to make them before Your Honors today. As Your Honors are aware, jurisdictional and admissibility challenges are complex, both factually and legally, and they require some time for the prosecution and, no doubt, representatives of victims to respond adequately. As Your Honors have foreshadowed, it may be that Libyan authorities will also be invited to make submissions, which will also take some time. 2 weeks prior to the confirmation hearing will be a very intense period for both the prosecution and the defense, but also the victims' representatives to prepare. Before, during the confirmation hearing, and afterwards, there's significant work that needs to be done. And responding to a jurisdictional and an admissibility challenge at the same time would significantly derail our preparation. Your Honors have, of course, a discretion to determine at what time, in accordance with Rule 58 of the statute, you hear these submissions and at what time you decide them. And it is, of course, within your discretion to determine that you will decide the issue of jurisdiction and admissibility at the same time as you decide issues of the confirmation hearing. Deciding, of course, those issues first, and then the issues on the merits of the confirmation hearing later. In our review of some of the jurisdictional challenges raised in other cases, they were made significantly earlier than 2 weeks before the confirmation hearing. So, for example, in the Duterte proceeding, the jurisdiction challenge was made nearly 4.5 months before the anticipated first date of the confirmation hearing. And in the Abdel Rahman case, jurisdictional challenge was made 2 months in advance of the confirmation hearing. As a general principle, if the defense already knows what the issues are it wishes to raise on both these matters, it should be making them at the earliest opportunity. What the prosecution and no doubt the chamber wishes to avoid are any delays to the trial itself and the start of the ultimate trial. So the earlier these issues are able to be decided and if necessary appealed, the safer the trial date is. Nonetheless, we will be guided by any orders your honors make in relation to the procedures to be followed and the timelines. Our request is that should the defense file these two significant challenges 2 weeks before the confirmation hearing, that our deadline doesn't start until after the confirmation hearing. The deadline, the start of the time period to respond would begin on or about 22 May, when the confirmation hearing is finished, and will progress for the time period the chamber determines appropriate, whether it's 20 days or otherwise. And then the chamber would decide the issue first in the context of its confirmation hearing decision. Thank you.
Merci beaucoup, Madame la Procureure.
Thank you very much, Madam Prosecutor. Now, we would like to hear from the representatives of the registry. I believe I prefer that we go into private session for the upcoming exchanges. Madam Court Officer, please, private session.
We're back in open session, Madam President.
Judge Motok. The Chamber takes note of the intention of the defense to challenge the jurisdiction of the court as well as the admissibility of the case, and that they expect to be in a position to submit such a challenge in writing 14 days prior to the confirmation of charges hearings. The Chamber recalls that the defense is empowered by the statutory instruments to raise such challenges at any time before the commencement of trial. It is of the opinion that it would be appropriate and ideal to entertain such challenges and to rule on the issues concerned before or jointly with the decision on the confirmation of charges. That being the case, and to avoid setting any rigid deadlines, the Chamber strongly encourages the defense to present such challenges in writing at the earliest possible opportunity, and ideally before the end of the month of April. Now, the third point on our agenda is, at the request of the parties, the reclassification to public, and especially certain written submissions and decisions in the case file of the case. I will give the floor to Madam Prosecutor for that.
Yes, Your Honor. It's a point raised by the defense primarily, so perhaps the defense has more to add. What I can say for the prosecution is that there are a number of filings and decisions that have been made confidentially or ex parte. This week, the prosecution has filed 4 public redacted versions of requests that it has made, and we stand ready to file further public redacted versions of requests and submissions should your honors so decide. Thank you.
Merci beaucoup.
Judge Motot. Thank you very much, Madam Prosecutor. Defense Counsel, you have the floor.
Thank you, Madam President. Simply speaking, we request that the OTP submits PRVs for all the formerly submitted files, upon which we will also submit a redacted version of all the documents submitted by the defense. Thank you.
Judge Motok, thank you very much, Counsel. The Chamber appreciates the concerns of the parties and recalls the importance of keeping the case record accessible to the public to the extent possible. In this regard, the Chamber welcomes the proposals of the prosecutor and of the defense on this matter, and orders the parties to consult with each other for the purpose of submitting public versions of the specified documents within the coming weeks. Henceforth, the Chamber encourages the parties and participants to submit public redacted versions of their written submissions as expeditiously as possible, and ideally a few days after the filing of the original confidential versions. This should enable the Chamber to release public versions within the shortest possible time. Now, the fourth and last point of our agenda relates to all other residual matters to be dealt with. First of all, in order to ensure the proper conduct of the proceedings prior to the confirmation of charges, the Chamber hereby decides to replace the automatic timeline of 10 days provided for in Regulation 24 of the Regulations of the Court with a time limit of 5 days. This adjustment is valid as from now, and for the submission of all responses following the notification of motions or written submissions. If the parties or participants are not able to submit their responses within the prescribed period of 5 days, they shall be required to apply for a time extension before the expiry of that timeline in accordance with Regulation 35 of the Regulations of the Court. Secondly, the Chamber would like to inform the parties and participants that the next status conference will take place during the week of the 20th of April 2026, highly likely on the 21st or 22nd of April 2026. The parties should once again consult with each other and file submissions jointly to the extent possible by the 13th of April 2026. These submissions will make it possible to update the Chamber on their state of preparation for the confirmation of charges hearings. Once again, the parties are called upon to propose any items that they would wish to have included on the agenda of that third status conference. Lastly, and from a more general perspective, the Chamber has taken note of the written observations of the parties, and in particular the imminent submission of an application for interim release, as well as other issues linked to their preparation in anticipation of the confirmation of charges hearing. These submissions will, of course, be the subject of an exchange of filings in the coming weeks and may, as necessary, be dealt with during our next status conference. Unless there is a request to take the floor, we have now come to the end of our hearing. I would like to thank all the participants, our court officer and court clerk, the security officers, the AV team, as well as the interpreters and court reporters. Court is hereby adjourned.